are preparing to live stream the meeting. It's loading.
I see it.
Okay, let's see.
The meeting is now streaming live on YouTube. You can release your video order here. Because I went to that, so now I went to the link that you sent me, just because I was going to track it on my iPad, but I'm not seeing a live feed yet.
Try refreshing that link page. It should be up.
It is.
Okay.
Oh, that's more manageable than here. It is. Oh, God. Yeah, I'm glad we've got 0 viewership.
So somebody can view it later.
That's good.
This first one will go so well, we'll start to get negative viewers, people just blocking us.
That's right. Oh, boy. So, so first off is with Ely.
And the other, oh, that's written on your.
I wondered. Holy cow, waiting room's filling up. All right, so let's go ahead and do credit management versus Mariah Forebear, so we can have Miss Ely come in.
Okay, so that's where we're running into a problem. Hold on. I can't see anyone in the waiting room.
Oh, so that would just be up to me. Okay.
I think it's because we need to make clerk magistrate co-host, but we'll work on that when we have a break.
Gotcha. All right, I've got Miss Ely, so we'll go on the record in CI 21-412, Credit Management Services Incorporated versus Mariah Forebear. Ms. Ely appears for the plaintiff. There's no appearance by the defendant. Let's see here. So there's a certificate of service in the court file to Mr. Oostdijk, who apparently at one point was Miss Forebear's attorney. I have a note that Mr. Oostdijk is not appearing this morning, but nonetheless, there's a certificate of service and a notice of hearing this morning, February 7th, 2022, 9 a.m. Mountain Time here in the Butte County courtroom. And this matter is set this morning for plaintiff's motion for summary judgment. And then Ms. Ely, did you have evidence to present?
Yes, Your Honor. I would offer Exhibit 1, which is the affidavit of Jolene Gackemeyer and attached discovery documents, which was previously filed with the court.
Is it like e-file? Karina, did we get exhibits in the mail or? Well, we've got
It's
it.
attached to the motion. So
Okay. Ah. Okay, and then we have. Okay, there we go. All right, so exhibit one, then, that's how it's marked, that's received, that's the affidavit. And then the accompanying request for admission. I'm sorry, go ahead, Ms. Ely.
Thank you, Your Honor. I would also ask the court to take judicial notice of the court file, specifically the statement of undisputed facts and evidence index, both of which were filed with the court on December 31st, 2021.
And the court takes judicial notice then of the annotated statement of undisputed facts and the evidence index.
Thank you, Your Honor. I have no further evidence.
All right, so on the evidence then, the court finds that the motion for summary judgment then is sustained, and that there's no genuine dispute of any material fact, and that the plaintiff is entitled to judgment in the amount paid for in the complaint, which are, there's this order that's been provided, order of judgment, and it says that the principal balance is $25,908.98, and then $59.53 in court costs, and then we'll also include then the post-judgment interest at the statutory rate. Are those numbers, are those all correct then, Ms. Ely?
They are, Your Honor.
All right, that's great. So I'll go ahead and execute then this order that you provided. Is there anything further than this morning?
Not today, Your Honor.
All right, thank you.
Thank you. May I be excused.
Thank
Thank
you. Yeah, yes, yes.
And I think I got the co-host thing figured out. So whenever you're ready, let me know and I'll let the other two in for the next hearing.
Okay. So is that Sammy Schmidt? Is that the person for, last time it was an Adam Post that appeared in this State Farm versus Ramirez case?
Yeah, and I'm showing Sammy Schmidt is now the attorney of record for defendant.
Okay,
It looks like she entered an appearance of counsel.
Okay, I can call up there and help them now.
all right, so they filed a motion for something. All right, so do you want to give that, bringing them in a go then, Chelsea? The attorneys? You got it. All right, so I've got Mr. Carney and Ms. Schmidt. All right, so we'll go on the record then. This is CI 20-181, State Farm Mutual Auto Insurance Company versus Wayne L. Ramirez and Kroll Incorporated. And appearing are Ms. Schmidt for the defendant, Mr. Carney for,
Plaintiff.
okay, and yeah, it was a separate case that, okay, for the plaintiff. And then this matter was set for a status conference. I see that the defendant has filed a motion for summary judgment. Should we go ahead and set a hearing on that motion?
Yes, please, Your Honor.
You suppose that'll take about a half hour?
Yeah, I don't see us or our side needing any more time than that.
That sounds about right, Judge. I'll have a couple of affidavits and a resistance to file within the time allowed by the court rules, but I guess if we could look at the court's schedule and look at our schedules and see if we can't get something finalized, that would be great.
I'm looking at March 14th, if that's not too soon. And I've got that day completely open.
Supposed to be in Chicago that day, Judge, depending on COVID, but as of right now, I'm slated to be at a conference in Chicago that day. But since if we're Zooming, I could maybe step out to, I guess, depending on what you'd like to do.
That's right. Maybe let's look at March 9th. Actually, that's another day that I've got wide open, if that works better.
We're scheduled, we're slotted in for a trial on March 9th and 10th. I don't think it's gonna go, but right now it's booked. I'm sorry, Your Honor.
We could do March 21st in the morning. Well, no, I've got a trial to the court. Oh, that was a different day. Okay, so March 21st. Which one is that? How about March 23rd?
That day works for defendants for me, yes.
That works for us too, Your Honor.
So how about March 23rd, 9 a.m. Mountain Time?
That works.
Yes, that works.
Excellent. So hearing on defendant's motion for summary judgment, and anything further than Ms. Schmidt this morning?
I just didn't know how you wanted to handle the briefing schedule. If you would like Joel and I to just agree on dates, I'm happy to do that. If Joel is, otherwise, if you have a specific briefing schedule, we can do that as well.
My preference is always, if the attorneys can work it out between themselves, I like it. So it looks like you both are comfortable proceeding in that fashion, so that's fine with me.
Okay, that works. Thank you, Your Honor.
That works.
Thank you both. All right, your excuse. Thank you.
Thank you.
Have a nice week. Bye, Sammy.
Bye. Thank you.
Okay, I don't see Marissa for the Cody Bishop probation review, probably something that will just be take a look at the record. Otherwise, I do have on the case that's set for 9:15 MRC versus Rosales. I do have both plaintiff and defendant in the lobby.
Okay, do we, on this Cody Bishop, did he pay everything?
We have not scheduled it in the last. I don't see anything due up here.
Awesome, so we can just. Elimination. Next one. So that's Bishop. All right, I'm ready for the small claims.
Karina, do you want to get them or do you want me to?
Oh,
I don't know, they really.
I was going for the Zoom waiting room. And I was like, hey, wait a minute.
Okay.
Two watching now. I'm one. Are you the other?
Yes.
Good. I hope it stays that way for now.
Morning.
Morning. All right, so we're on the record. This is SC 22-1, MRC Incorporated versus Manny Rosales. And Mr. Rosales appears. And what's your name, ma'am?
Diana Munt, MUNDT.
And are you owner of MRC?
Yes.
That's fine. This matter comes on this morning for small claims trial. And as an initial matter, just kind of some of the rules of the road, the small claims court, it's an informal procedure. So the rules of evidence that would apply in a typical trial don't apply in the small claims court. So what that means is that each of you will have an opportunity to have the court look at all the documentary evidence that you want me to take a look at, hear all the testimony that you want me to hear. And so it just makes the process easier for the parties. The plaintiff has the burden to show by a preponderance of the evidence your claim. And then after you present your evidence, then Mr. Rosales, you'll have an opportunity to present evidence. And then after Mr. Rosales has an opportunity to present his evidence, then you would be able to present rebuttal evidence. And what that does is it just gives each of you an ample opportunity to let me know everything you want me to know about your case and not speak over one another. And just please direct all of your comments to the court. Whoever's unhappy with the decision of this court would have 30 days from the date of the decision to appeal to the district court if you want to. Typically, what I do before we get started is I'll give the parties an opportunity to visit about the case and see if they can come up with an agreement or settlement between themselves if they think that that would be helpful. Have you folks had an opportunity to visit about this at all?
No, we haven't.
Do you think it would be helpful at all to?
I don't think so because I've tried several times to contact him, so.
Okay, that's fine. Well, what I'll do initially is I'll have you both raise your right hands. Do you solemnly swear and affirm with promise under penalty of perjury that the testimony you'll give in this small claims trial will be truthful in all respects?
I do.
I do. All right, that's fine. So, Ms. Monk, then you can go ahead and present your evidence.
Oh, okay, this is just a letter today. Okay, so I guess, what I was wanting to do is, he had promised to pay on his rent and on, the end of December when he moved out. And I even have, a text message that if I will wait till the end of the month, he would pay me an extra $100 for late fees if I would wait till the end of the month when he got a chance to move out. And I haven't heard anything from him, and I've tried several times to contact him by phone and text and stuff like that, and I haven't been able to reach him or anything like that. And then also the rent also it includes the all the utilities and also the cable. So the rent per month is 500, and so that is due for December. And I have a text here saying that he will pay me if I wait, like I said, the 600 for that. And then upon checking out the house, he never did get all of his stuff out until, and we didn't even change the locks till mid-January. And he left a lot of his clothes in there, the refrigerator completely full of food and the cupboards completely full. And we have several pictures of the place. And it was just painted 6 months prior to moving in by my previous renter, Donna Tiger. And so it's got a lot of damage to the walls, and that has to be repainted now. And the backyard is clear full of used and broken furniture. And so that's going to take a great big one of those roll-offs to come and, be parked there by H&H and have all of that stuff loaded up. So that's going to be quite an expense as well. And I do have pictures and I have text messages if you'd like them, showing that I did try to get a hold of him several times. And so if you want me to show you those. And then even the 29th of December, I said, checking to see when you would be out of the apartment and returning the keys. He's never has returned the keys to the apartment either. So that's what I do. If you want to see pictures and text messages, I have them here.
It might be a good idea if you want to bring them up, I'll mark them.
This is where he says that acknowledges that he owes me for the December and that he will pay it if I wait till the end of the month. And here's several pictures of the yard and the apartment as well.
So I'll mark exhibit 1 will be the text messages. And then we'll just mark each one exhibit, all the photos, and that'll be exhibit 2. All right, then did you have any further evidence, Ms. Monk?
Yeah, I don't think so. I need.
And then Mr. Rosales, did you have some evidence that you wanted to present?
Yeah, so well, it's on phone, so I don't know how a video recording would be if I have to like get it downloaded and sent to a file. But anyways, my with the recordings that I have, it's showing that with the due to the maintenance, like so I caught up on my payments to her because in October I got injured as a followman. I was working with her throughout the whole year and tell up to my injury. And then I notified her that since I'm going to be out for work for a while, that I'll need my paycheck to at least get to my surgery so I could get my arm fixed and then be able to recover and come back to work and stuff. But kind of told me to kind of figure it out myself. So she just held on to my paycheck in October. So during then, so I just kind of figured it out myself. I caught up on my rent, then paid her. I got my last check and then I notified her after I followed her, paid up my November's rent to tell her that I was moving out and by the end of December in January. And after all that, she was notified through this summer about her maintenancing on the sink. The drain didn't work apparently, but then after that, she left, that never really got fixed, so I couldn't really have anyone else come and look at what else the prior fixtures that needed done, like the heater that needed fixed. And she'll say that she wasn't notified, but they even have long waited for the sink to get fixed, following that I've been paying her since summer, since June. There was not even really no maintenance being fixed in my place either. So that last month, yeah, I did fall behind because I was trying to prior to find a place, which I finally just got into housing.
So you really don't disagree that you owe 600 in rent?
I do agree that I owe that, but like, prior to damage, so, okay, I also called Keep Alliance Beautiful for her until after our argument over my paycheck, so I didn't bother calling Keep Alliance Beautiful to come get their cans that were all blown to the side, you know, outside. There's a bunch of cans that were laying out there, and I was injured at the time, I couldn't pick them up, but then I just kind of left it as the, to me, I didn't feel like it was like my concern that.
All right, and then I take it, Miss Munt, you don't have any, or at least I haven't heard any evidence about the repair, the painting, those damages. You haven't had those repairs done yet?
The painting is fine.
I'm sorry about,
There wasn't any evidence about the damages that you're talking about?
of the painting,
the
not
painting.
until he completely moved out. I didn't notice that there was any painting until he moved out. And scratches in the wall, you don't see that until the people move out.
Okay, that's.
And I wasn't aware of any painting issue at all until he moved out.
Okay, do you typically do a paint job in between tenants or not?
Not normally, no, but the lady that had done it before, 6 months prior, she just went in and painted everything, and it was fine with me to do that. So I just bought the paint, she painted the whole place, so
So you
if they
had
want,
that
she changed the color is what she did.
Yeah, you've had that done before.
Correct.
Do you remember how much it cost?
It was about 300, I think, for the paint, and then she did it herself.
So it'd be $300.
I'm assuming probably, yeah, because there's some paint left, not very much, but there's a little bit left, so we could use that. So,
And then you had something that you wanted to say, Mr. Rosales?
It's like, yeah, the painting was fine, so I can't really say nothing about the walls. But like, I guess there's certain maybe colors on the walls that probably needed cleaned and stuff that I left behind. Like she said, like the clothes and stuff. I just kind of took pretty much what I felt I needed left, and since I kind of figured since she held on to my check in the past and I did have it on record here, I figured since I was gonna clean up and pretty much if I was to, I probably wouldn't see my deposit. So I just kind of, whatever was left and stuff, so I just figured she could keep the 200 deposit and finish throwing away whatever I left.
Okay, so your deposit was $200.
Yeah.
And you're keeping the 200.
yes,
Okay, so you'll get a $200 credit. And then Mr. Rosales, you haven't turned in your key?
Yeah, I actually lost my keys when I got injured during all the mess that happened while I was out of town, because I went out of town and then I got injured. I kind of went straight to the hospital and then I kind of lost some of my stuff during all the incidents.
Anything further than this month?
no,
Anything further, Mr. Rosales? All right, so the court finds then that the plaintiff's met its burden to show by the preponderance of the evidence that Mr. Rosales, you owe rent in the amount of $600, damages of $300. That total is $900, but you get $200 credit because you made that deposit, which is not going to be returned to you. So judgment is in the amount of $700 for the plaintiff against the defendant. And I'm going to tax the court costs, which are $46.50 also to the defendant, along with the imposition of the post-judgment interest at the statutory rate of 2.223%. So that's the judgment and order. And you can both stop at the clerk's office and pick up copies of the paperwork. So we're adjourned for this morning. Thank you.
All right, thank you.
Thank you both.
Thank you.
We're just. Right?